Hi everyone, how are you? I added a couple of things to my setup here with so that we can really see that I'm the one with the crystal ball and I can really see into the future and I can really reveal things. But I still have my favorite Christmas Starbucks mug, so maybe I have a whole Jack skeleton. What's his name? Jack. I don't know. um that because what is it, Nightmare Before Christmas, where it has Christmas and Halloween stuff. That's kind of what I've got going on because I just love this mug. His name isn't, it's Jack. Is his name Jack Skellington? Jack Skellington, that's what it is, not skeleton. So have that over there. Have my little favorite towelette. That's an actual drawing of me and Boo, if you didn't know. Just kidding. And I have this from last year at the Dollar Tree when it was still $1 and got that beauty for $1. And I've got this new one and I pulled out this is also artistic interpretation of me without, I don't really have purple hair, but otherwise this is actually me and what I look like most days when I'm out in my backyard with my coven and, or coven, it's called a coven, right? So let's see here. So here I am with my crystal ball. I want to look at that. She glows. Look at this. This is from Bath and Body Works, I think 2 years back. And it holds the hand sanitizer in here. So I always keep the Halloween vampire blood one in this one and put her away until it's time to get her back out. And she's so cute. I mean me. This is me. It's actually me. See? It just clips onto my briefcase because it's so professional. My professional channel here. With my LED crystal ball. I'm going to put her right there. Maybe she'll stand there. And then my Dollar Tree thing from last year where it lights up right there and it says, it's just a phase. Oh, and I've got a box of generic Cheerios there. I had my kiddo run uptown to get me some Cheerios because I was empty. I was out. And apparently other people are as addicted to Cheerios as I am because there was none in the grocery store. So I have my generic Cheerios over there in case I get hungry. And then I have this one that caused so much controversy last year. Did this light go out? Let me see here. Oh, actually, yeah, this one was a $3 one last year. Oh no, the light went out. Oh, what was I expecting? I was expecting, let me see here. It was working. I might have to pull this out and change. Oh, Lord. I wonder what kind of battery it has in it. Oh, there it is. It just came back to life. Oh, there we are. See, and it has a little, well, it worked for a second. Come back. Oh, don't die. Come back. Really? Really? I am not in the mood. If you guys heard, I just totally lost my temper in my live. It's really hard to, I don't have mods because I would feel guilty using somebody else's time on my stuff. There we go. I just don't feel right about taking somebody else's time to sit there while I talk. I don't know how people don't feel guilty having mods. And I mean, I know that some people are happy to do it, but I don't know. I just feel bad. So I always love to include everybody in my chats and make sure that everybody is feeling like they're a part of the discussion. And I was talking, which is sometimes hard for me because of my long COVID issues and everything else. So I was talking and I was saying something else and this person came in and their thing was dragonflies, something. And I love dragonflies. So I was like, hello, dragonflies. I meant to say that, but because I was in the middle of saying something else, I said dragon. And so, then I just I was like, oh yes, dragonflies. I love my dragonflies, just, made a joke of how I mispronounced dragonflies. As those of you who have been with me from the beginning know that I'm a huge lover of dragonflies. Do you guys remember maybe I can't remember which. It's on a couple of my videos where I have the big, huge dragonfly that chose to use my home as its resting place, and I have it in a beautiful container, and I did some photography with it on a couple of Starbucks cups that were really iridescent, so it looks really cool. I mean, I actually love dragonflies, so I said it like that, and I was like, dragonflies, oh yes, the dragonflies. And so this person said, I'm gonna leave, and I don't appreciate that. I'm a clean and sober person, and I don't appreciate you saying that I'm a druggie. And I'm like, oh my god. So I guess I've been hanging around with my British friends too much, and I just flew out with the C word. I think it's because I was also talking about Michelle, and that tends to really get my profanity level up there. So I just rattled it off and deleted and blocked the person and called him the C word. And I apologize to anybody who heard that. That was not, I would like to say it's not indicative of who I am, but maybe it is. I don't know. I just have no patience for anything right now. I'm having this really bad, issue with anxiety this week. I have if you've ever experienced that feeling of impending doom, um, I've had it a few times in my life, and I don't know if it's just all of the negative energy that seems to be in society right now, where it's hard to find people to talk and smile and laugh and be nice and reciprocate back and forth in a conversation. And I think I'm just really kind of burnt out and sad on humanity as a whole. And every time I go out, it just seems like it's so frustrating and expensive to do anything or go anywhere. And it's just hard all around. You guys feel that too? So I don't know. I just kind of feel like I'm in a funk, and it doesn't take much to just blow my lid. And because I don't have a job or anybody to answer to, my profanity level is at its highest rate. So again, I'm sorry to anybody who had to hear me rattle off like that. I mean, it'll get to the point where I will probably have a mod or two just so that that doesn't happen. I don't get frustrated when something like that happens and derails the thing and somebody comes in and acts like a victim. I hate the victim mentality. I can't stand it when somebody plays the victim. And that's just the way it came off. So, I'm old and grumpy, I guess. Maybe that's it. I need to go on another road trip. I was in a good mood on the road trip. I'm a person who I don't really like have moods per se. Like I wake up happy every day, grateful to be alive every day for everything that I've survived. And then if things piss me off, they piss me off, and my Italian Scottish blood will get boiling, and I'll boil over and then wrap it back up. And then I'm fine again. So I don't usually have like bad moods. I'm not like one of those people. But like I say, just something's really upsetting me in my very core right now. I don't know what it is. I don't know. I've been watching the news more often, and maybe that's it. I gotta knock that off again. So just go back to this. Just go back to my crystal ball. My crystal ball. And like you guys are seeing from part 10 of my Katie Joy series, the balls on that woman. The crystal balls on that woman. I mean, I'm shocked at the things that she has said them and not feared repercussion. I mean, when people look at this on the surface, they're like, gosh, any one of us could be, brought into court at any time for slander and libel. And no, there are, definitely elements of slander and libel that need to be proven. And, we have freedom of speech and whatnot. And people who died for that right, for us to have it. And it's a right that I respect. And know that even when I made a mistake and lost my temper today, it's because I have that freedom of speech. Um, and then you see what Katie Joy has been doing to people, and the fact that she brags and says that she won't be happy until they are nothing, until they have no money. I don't know where that kind of hatred for people comes from that you have no relationship with. Just like with Tati and all of the things that she said, she has no relationship with it. It's not like she had a business relationship. It's not like she's, Jeffree Star. And she just kind of goes after these people that have money, that are popular, that are beautiful, have personalities, are mothers most of the time. And she really has a burning hatred for other women, and it's something else. So this 7M thing, she really went for Miranda Derrick, and that's where, it's that hatred of a beautiful woman coming in, and she's acting like she's Captain Save-A-Ho and trying to rescue her from this situation that she thinks, well, she's using as an excuse as to what is fueling her to say these things. And Miranda herself, her family, everybody has been like, we're fine. We don't need your help. And none of us want to go after somebody and be responsible for billions of dollars being lost at behest of our mouth. It's mind-boggling. If you have been with me through all 10 episodes, you know what I'm talking about. And without further ado, I'll pinch my witch one more time just for because she is so cute. Oh, would you make your ball glow, ma'am? Let me see. Witchy poo. Oh, there, I just had to say hello. So there you are. Look at her, looking at this. Little witchy poo is looking at this, going, what? My crystal ball sees here that Katie Joy is in a lot of trouble. See, did you hear her? That's what she saw in her crystal ball. And like, you guys are so smart, and the things that I put over in my community post when you guys interact with me, I love it. And then, we build on each other's ideas. And when I put up, I saw in a Reddit post where somebody was laughing about how it looked like, it was made to look like a woman had sent a direct message to Toad and was trying to hook up. And so I posted it, not knowing that there was a backstory to it, that woman is one of several attorneys involved in something else. And so that's where the picture is from. And it was a joke or something that they were doing back and forth, her and Toad. I don't know. They have to do something other than, as she claims, they fornicate, or she fornicated with others. I have a hard time believing that more than one person would fornicate with her. She has a child, so somebody did, but I don't know. Anywho, as somebody wisely put out, that although the text thing isn't what I thought it was, it's a huge learning opportunity and insight into how easily Katie Joy can manufacture fake texts. It's nothing to her. When I realized that, I had like all of this download in my brain, like she could very easily be creating fake texts and fake messages to show in a trial as her sources that were telling her things. And I hope that these things that we are seeing are then seen and used in court. That if we noticed how well she can fake a text, which my kids tell me is really easy to do. It doesn't, there's an app that can do it. And I know that I've seen it in other things, but Katie Joy purports herself to be a troll, and that may be the only one thing that she's ever said that's true. Because if this comes down to a trial, she's going to have all these things and be like, this one messaged me this, and this one messaged me this, and I'm a real reporter, and I'll never reveal my sources. I'll go on a hunger strike before I'll reveal my sources. And then she'd have all these people who are like, yes, look at her, she's on a hunger strike. And be like, no, she created that. There are no sources. She completely made it up because she likes to get something that will get her a lot of views to gain her a lot of money. And she profits from lies. And that's what I've seen in my crystal ball. To set the scene, in my Christmas mug, my several years old Christmas mug, my favorite mug. I could go back in time when Starbucks made cute mugs. And do you guys remember when you used to, when Starbucks used to sell these and you'd get your drink in it for free? So the drink that you were going to get that day, you'd save that cost and it would be in the mug. So, encourage you to start using it, save, recycle. And, the drinks were like $5 then. And that's when these mugs were like, $10.95, $12 max. Now, I have a ton of them because I collect them and have since the 90s. This one, I think I was showing you guys this one, how old this one is the other day. It's got some 2001. Yeah, that's right. Oh, what? 2001, 2004, 2004. I just loved the way they used to make them like this. I love that Christmas tree and the way that it's so whimsical. I really love whimsical stuff, as you might have seen. So I'm drinking my lavender lemonade tea that I got from the Wisconsin Fair with the true honey granules in it. I love it. My throat is still pretty sore from the wildfires and all that good stuff. So. Okay, no more dog do. We gotta get on board here, Witchy Poo. We're being very unprofessional. Witchy Poo, you gotta go there. There you go. And Boo Boo is next to me at my feet, sleeping nicely. And here we go. I have one of my pretty pens. I think I ordered these years ago. On Jewelry TV. It's got this rhinestone here. It has this magnifying glass. Look at that. Katie Joy. And it has a light on it. So I always keep one of these in my briefcase because it's just so awesome. If you need a little bit of light. Or, cool thing, huh? And it's, of course, it's a pen. It's a real functional pen that has a light and has that. I need one that's like this, but a spy pen. So I think what I'm going to do is rest. We'll do this. And we will rest the phone here. We'll be just fine unless Ma Kisses comes and flies on us and knocks everything over, as she has been known to do when she decides that it's my bedtime. And then we can keep you focused on. I love this little crystal ball. I really do. Let me do that. Or I hope that it gives some good thumbnails there. Let me see. Maybe I'll do that one. That? Maybe. Yeah, we'll do that for a while. Okay, so here we are. In the state of Minnesota, the county of Wright, in the 10th Judicial District in District Court in a default case type with 7M Films Incorporated, 7M Incorporated, Robert Shin, Miranda Derrick, and James Derrick as the plaintiffs lined up. They are taking on Catherine Mansky Paulson, aka Katie Joy, and Without a Crystal Ball, LLC, as the defendants. And this here is a defendant's memorandum. So it's a memo. Defendant's memorandum of law supporting motion to compel and opposing motion for a protective order. Okay, now this one, just so we kind of know, this was filed in district court on Halloween of last year, 10/31/22 at 4:34 p.m., as we can see. And this one was written by none other than Jennifer Moore. All right, so we've got our traditional older lawyer who doesn't seem to have any clue of what her client does on a daily basis. Nonetheless, we're going to see what she wrote here. Again, dated last Halloween. How ironic, as I have this Halloween setup. I swear I did not know that before I got these treasures out from last Halloween. Just coincidental. With Troutman Martin Law, written by Jennifer Moore, attorney for defendants. But it's just one defendant. Even though Katie Joy likes to act like she's multiple people, she's just one person. Because Paul isn't on that insurance policy. It's interesting because with Minnesota being a 50-50 state, if something happened and she gets a massive judgment against her, I don't know if that will go down against him too. Does anybody know? So the introduction states that, and this is Jennifer Moore writing, so here we go. Jennifer Moore states in her introduction that the defendants ask the court to issue an order requiring plaintiffs to respond to discovery that was served August 5th, 2022, and which remain outstanding. Plaintiffs' excuse for refusing to respond to discovery is that they have... Oh my God, I can't read this. Look at this. Plaintiffs... So it starts with this little... She's got a hyphen at the plaintiffs. So we're doing this. We're going, plaintiffs' excuse for refusing to respond to discovery is that they are seeking a protective order. Not or. It says is that they are seeking a protective order. Look at that. This isn't me misreading. This isn't my COVID brain overreacting. This is language that was not checked over. You can't afford to have mistakes like this in a case where so much is at stake. As we heard in episode 10, we're talking about 7M being able to prove at this point that the dollar loss is in the billions for future contracts. And I'm sure that they'll argue that and say this and this couldn't be guaranteed and whatnot. And they'll whittle it down to $1 million. But we're not talking about pennies here. We're talking about millions of dollars. And the attorney is this irresponsible in her writing in this first page in the introduction. I have a problem with that. So, again, plaintiff's excuse, and I don't even like that. Why didn't they go, the plaintiff's excuse for refusing to respond to discovery is that they are seeking a protective order. Okay, that's the way it should read, but that's not what is here. This is a mistake, and I am going to write it here. Obviously, no one proofreads their stuff anymore. All right. Now, again, another hyphen to start this, which I don't understand why that is being done, but let's see. However, plaintiffs requested protective order is so broad that it would render the process of discovery completely meaningless, in that defendants would not be able to assist counsel in preparing the matter for trial. Moreover, much of the materials plaintiffs seek to protect under the proposed protective order are not remotely connected to their concern for privacy. For these reasons, defendants ask that the court deny plaintiffs' motion for a protective order and grant defendants' motion to compel discovery. Okay. Now the procedural history is as follows. On August 5th, 2022, defendant served its first set of interrogatories and requests for production of documents. In Exhibits A, B, and C of the Moore Declaration, it will show that plaintiff has not responded. The way that was written, that's how that showed it. On August 26th, 2026? What the? Okay, this is not good for my need to cuss today. Okay, we're going to turn this over and you're going to see that I'm not making this up. I can't make this up because we're going to go here. On August 26th, we go to the next part. On August 26th, 2026, what the? So you know what? It's all these people with their crystal balls. Apparently, Jennifer Moore can see into the future and see that in the year 2026, the plaintiffs brought their motion. And you know what she's saying, that this case is going to draw on until 2026. There probably isn't anything closer to the truth in this at this point. What in the? I mean, you know what? I am not pro KJ, but if I was paying as much as KJ is for an attorney, I'd be pretty mad that there are typos like this. And I'd be saying, what the, okay? I'm disgusted and shocked that this is the kind of thing going on and not being proofread by another person in her office. You know, Jennifer Moore is here with Troutman Martin Law. Couldn't she go over to Troutman or Martin? Go, hey, Graham, can you read this before I send it off? Because, you know, I'm in over my head here. I mean, something, anything, and not use the year 2026, because that alone would be enough for a judge to throw this motion out and say, you know what, come back to me when you can provide me something truthful, because right now what you've done is insulted me with something that is completely not true. They should be very glad that I did not complete law school, because I'd be a judge like that. I would be like, don't put this in front of me. Now, it goes on to say, plaintiffs brought their motion for a protective order seeking to sequester all discovery at the Office of Counsel for Plaintiffs, limit access to discovery material solely to defendants' attorneys, and provide that depositions be confidential and not disclosed to anyone other than the parties and counsel. On September 1, 2022, counsel indicated that it would not be responding to any discovery requests. There should be a comma there, but you know what? I need to just not even look at this. Until an order issues, its motion for a protective order is decided. There are too many words in that. What the? All right, I need to stop. Except for this last communication, plaintiffs have made absolutely no attempt to resolve any outstanding discovery issue or negotiate the terms of a protective order. It is my opinion, offside here. As you guys know, I opine more than I should, probably. I apologize, but this is just mind-boggling, and my mind goes a million ways when I look at this. She should be almost happy that there is a protective order so that her client will not have the information that the other side doesn't want her to have, because she has a history of just going here and pushing the lawsuits out as far as she can, because her goal is to get as much information as she can so that she can post it on the internet to get as much money as she can to turn it into her livelihood. Her attorney should be jumping for joy, hoping that the protective order is there. But she wants to use big words and not proper punctuation. So here we go. Now the argument, she states. Number 1 is that defendants' discovery requests seek materials that are relevant and necessary to prepare its defense in this matter. According to Minnesota Rules of Civil Procedure 2602B, permits discovery to be made regarding any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case, considering the importance of the issues at stake in the action, the amount in controversy, the parties' relative access to relevant information, the parties' resources, the importance of the discovery in resolving the issues, and whether the burden or expense of the proposed discovery outweighs its likely benefit. Okay. Subsection A here states that parties A, oh, I see, she put that in there, that the language didn't have an A. Okay, I gotcha. A party's failure to timely respond to interrogatories or make objections waives all objections except those related to privilege, work product, and experts' conclusions. Okay, once again, I'm going to skip a lot of the legal citations just so that this flows better. Thank you. Oh, actually, can you put that in there? Because he will gobble it up. Thank you so much. I appreciate it. You're really a great kid. Thank you. I'm sorry for the interruption. Anywho here. Oh, my kids. But regardless of the effect plaintiffs' failure to respond has on their own eventual responses and objections, their failure to respond to discovery, even with objections hereto, places defendants at a disadvantage with respect to establishing the discoverability of information under the rules. However, defendants' discovery requests were tailored specifically towards the claims made by plaintiffs in the amended complaint. The defendants' first set of interrogatories and its request for production of documents seek the following: completely non-objectionable information. Interrogatory number 1. To identify all persons who provided answers or other information in responding to these interrogatories, and, for each such person, state the specific interrogatory or interrogatories to which such person provided answers or other information. Interrogatory number 2. To identify all persons known to you, have discoverable knowledge, information, or documents that relate in any way to the allegations and claims set forth in the complaint or answer and counterclaim, or the subject matter of this litigation, and for each such person, identify the subject or subjects of the information. Interrogatory 3. List the names of any persons referred to in your answers to interrogatories 1 and 2 whom you have interviewed, and state the date, time, and location of each interview, and identify each person conducting or otherwise present at each interview. Interrogatory number 4. Have you taken or received any statements relating to the matters alleged in the complaint? If so, A. Identify each person from whom you have taken a statement, indicating whether the statement was oral, written, by a court reporter, tape recorded, or otherwise preserved. B. State the date, time, and location of each statement. C. Identify each person taking the statement and any other person present during the taking of the statement. And D. State whether the person from whom the statement was taken has been provided with a copy specifying the date and place thereof. Interrogatory number 5 says, state the names and addresses of each and every witness you propose to call in the trial of the above captioned action, and state the subject matter to which each said witness will testify. Interrogatory number 6, identify all persons other than your attorney with whom you have communicated about the issue since this case, giving the date, subject matter, and mode of communication. Interrogatory number 7. Identify all persons other than your attorney with whom you have communicated about defendants, giving the date, subject matter, and mode of communication. Interrogatory number 8 states, identify and describe all communications, emails, notes, letters, memoranda prior to the commencement of this litigation exchanged between the parties to this litigation. And document request number 1 is that all statements or other documents, electronically stored information, emails, and other tangible things identified in your answers to defendants' first set of interrogatories. And document request number 2 says, all statements or other documents, electronically stored information, emails, and other tangible things relied on in providing answers to the defendants' first set of interrogatories. Then we're going to 4. Sorry that my hands are so dry. They look like lizard hands. It is that time of the summer. I need to moisturize. Document request number 3, all documents that you will use or attempt to use as exhibits or introduce your attempt to enter into evidence at hearing or trial. Document request number 4, all documents relied upon by any expert retained or disclosed by you. Document request number 5, all notes, drafts, journals, or other documents referring to defendants. Document request number 30, all other documents which have not been specifically requested in the foregoing demands, but which are in your possession and relate to the subject matter of this litigation. These discovery requests all seek information necessary for defendants to test the veracity of plaintiffs' responses to discovery and to prepare their case for trial. They are also completely non-objectionable. Defendants' interrogatories also seek information that is a matter of public record. Interrogatory number 9. If you have ever been convicted of or pled guilty to a criminal offense, then state the following. A. The city, county, and state in which the offense occurred, and B. The court in which the plea or conviction was entered. Interrogatory number 10 states that if you have ever been a party to a claim, lawsuit, bankruptcy, workers' compensation proceeding, judgment, liens, or any proceeding of any kind in which claims were brought by you or against you in the last 10 years, then state the following. A. The dates of the claim, lawsuit, or proceeding. B. The name and address of the entity or person against whom you brought such claim, lawsuit, or proceeding, or who brought such proceedings against you, and C. The name or caption of such claim, lawsuit, or proceeding, the court file number and venue. Interrogatory 11. Identify each and every social media post plaintiffs have made regarding or referring to defendants, including any drafts. Ooh. That is going to come for each side. This is me speaking. I'm not narrating. I'm opining. Each side is going to ask this. When Katie Joy has to list off how many other people have filed a claim against her for this same reckless behavior, it's not going to be good. And, as we were talking in comments about how, yeah, technically the Tati lawsuit, wasn't filed right, so it was dismissed for jurisdiction. It had some teeth in it. And as stated in the comments, she had to it wasn't as clean as Katie Joy likes it to seem, that they just dropped it for this and that. There were other stipulations that were agreed upon. All of the lawsuits filed against her to this point have a very proven, clear and concise pattern of behavior that they're going to be able to show. That alone would, if I were an attorney, if I were an attorney, that alone would make me have a stern discussion with my client about their behavior and how it needs to be reined in, quite honestly, especially while this lawsuit is ongoing. And it doesn't seem like that has happened because we've seen what she's been doing. And I'm quite sure that other big eyes have seen what she's been doing too. Now, these interrogatories cannot possibly be objectionable insofar as they seek matters that are a matter of public record. They also seek information relevant to plaintiffs' claim that is necessary for defendants to prepare their defense. Next, defendants seek information related to business and employment practices and also damages that plaintiffs have squarely placed at issue by virtue of bringing this lawsuit for defamation. Interrogatory number 12 says, identify all institutions at which you hold bank accounts of any type and provide the institution's contact information, the type of account held at that institution, the names on the accounts, and the names of any signatories on those accounts. This interrogatory is necessary to subpoena bank records and determine who, in plaintiff's organization, has custody and control of company funds. This information is also necessary to defend against plaintiff's claim for damages. Interrogatory 13. Identify plaintiff's employment policies and best practices, including but not limited to content and routine creation, access, and management of employees' social media accounts, communication with individuals not affiliated with 7M or Shekinah Church International, and compensation. Interrogatory 14. Identify all past and present employees and contractors of 7M and any of its affiliate organizations, listing each person's name, date of birth, address, phone number, and term of employment. Ooh. Interrogatory number 19. List the names and contact information of any and all 7M dancers during the relevant time period and describe who pays for their housing. Right there. That's what Katie Joy wants. She wants this because she wants to go and run and say, see, he commands where they live. See, he's controlling. See, and do the things that she does. That's why they're smart to put a protective order on this. They really are. I think that Amber Stavig is doing an excellent job. Document request number 12. Full employment files of each and every one of 7M's current and former employees and contractors, including each person's name, date of birth, address, phone number, and other employee information kept by 7M and term of employment. Document request 17. All documents and communication regarding terms of employment policies and or best practices created or provided by 7M to its employees, including drafts. This information is necessary to identify witnesses who may be able to rebut plaintiffs' claims that defendants' statements were false and clarify the relationship between employees. Ew, there's a bug. Boo, there's a bug, help. He usually catches all the little bugs that come in. How'd that bug get there? Ew. Glad it wasn't a little spider coming down. They see this creepy setup I have. And they're like, ooh, we want to be part of your creepy setup. Nope, not going to happen. Sorry, documents request number 17. All documents and communication regarding terms of employment policies and or best practices created or provided by 7M to its employees, including drafts. Okay, that's huge. This information is necessary to identify witnesses who may be able to rebut plaintiffs' claim that defendants' statements were false and clarify the relationship between employee and witnesses that may possess relevant information. Are you guys seeing how big this case could get? I am. Plaintiffs claim that defendants made false statements regarding the participation of plaintiffs in the Shekinah Church International. To that end, defendants sought the following information. Interrogatory 15. Identify all residential and commercial real property. It says it like that. It's weird. Identify all residential and commercial real property owned by plaintiffs and their affiliate organizations, including but not limited to Shekinah Church International. Interrogatory 18. Describe in detail the process for accepting tithes, gifts, and donations from A. members of the Shekinah Church International, B. 7M's dancers, and C. anyone else not listed in and B. and explain first gifts and man of God gifts. What are these Mog gifts, man of God gifts? I want to know. I'm going to write a little thing here. I'm going to research that. Man of God gifts. I shouldn't have just neighed like that. I'm going to summon Hoorah. Anyway, interrogatory 20. List all businesses, including their location and registered addresses, owned wholly or in part by anyone who is a member of the leadership of Shekinah Church International. Document request 10. A full financial accounting and tax returns of Shekinah Church International. Document request 13, balance sheets, profit and loss statements, and yearly tax returns for any business owned wholly or in part by anyone who is a member of the leadership of Shekinah Church International. Document sufficient to show any contributions, donations, tithes, or other gifts, including monetary, in-kind, or other, given to Robert Shin, 7M, Shekinah Church International, or any other organization or individual affiliated with Robert Shin. Document request 21. All documents and communication regarding Mission 2020, including but not limited to incorporation documents, names and amounts of investors, and financial records. I'll look that one up too. First mention of some of these things that I've seen. Interesting. Mission 2020. Oh, you fly. Better watch out. I'm not in the mood. I'll call you a C word too. Just like I did to the dragonfly. Anyway. Oh my God. Oh, what a day. Let me see here. Document request 22. All documents and communication regarding any other business owned, created, filed, or funded by plaintiffs, including but not limited to incorporation documents, names, and amounts of investors and financial records. Document request 23. All documents and communication, including, okay, what is this word? Proselytizing materials created and or provided by Robert Shin or his associates for Shekinah Church International. Proselytizing? Proselytizing. New word here. I love being a student of life. I always learn things. Every day is a new opportunity, you know what I mean? Proselytizing materials created or provided by Robert Shin or his associates for Shekinah Church International. Document request 26. All communication regarding and including communication with and about 7M employee contact with their non-7M and non-Shekinah Church family members, friends, and acquaintances. Okay? Now, me opining again. Just this right here. Those of us who know the behavior pattern of Katie Joy and how she is basically a shock jock, the Inquirer, that she is a person, it appears, to understand profit and loss. She has learned how to play it cool as a cucumber, ride the storm, don't let them see you sweat, make the money, and cut your losses. So let's just use simple numbers here. Let's say that she sees, oh, okay, I'm going to make $100 on this lie. And you know what? They're going to come after me, and okay, I'm going to fork over $10. I'm going to fork over $10 here. And then, okay, you're going to slap my hand. All right, here's the final $10. I made $70 off of that lie. I paid out $30. $100 was gained. So if you take every $100 that she makes for every single lie, look at how it adds up. She's getting that 70, she pays out 30. Just as a basic example. So if she had her grubby little hands on all of this information about 7M and Robert Shin, the Shekinah Church International, Miranda Derrick, all of their former employees, she would take it upon herself to go and search out every single one of those former employees and see if they're disgruntled at all and see if they'll back her up, because all she's got to do is get one. She's nothing if she's not maniacal. This is why this protective order needs to be in place in this case of all cases, because she's not going to stop until she is stopped. That's proven. Like we say, the stone's on that woman. I wouldn't be able to do it. I would have done left the country by now, probably. Never touched the internet again. Been like, oh my God, I'm sorry. I don't know how she does it. I don't know. It's shocking. But then what I don't like here, and this is of course in our judicial system, is that so often the victim, the plaintiff, is re-victimized in that they have to divulge every single aspect of their private lives. And that's what is at stake. So that's probably why other people don't go as far as 7M is willing to, because they don't want all of their secrets and all of their lives to be told everywhere. It's a huge invasion of privacy. It would make me or I would imagine most people feel very vulnerable and exploited. This is, as in a case of grape. Um, the victim would have to divulge all previous partners, what she was doing that night, what she was wearing. We all know how grape victims get re-victimized, and that's why they don't come forward. They are cracked open, and people figure, you know what, they're going to cut their losses. They're going to take some antibiotics or the morning after pill or whatever, and not go through a trial that's going to have every single thing that they've ever done out for the court of public opinion to judge them, to see whether or not they asked for it or not. This is an emotional graping to have to be Robert Shin, to divulge all of this that he's worked for. And I'm sure that they had to think long and hard about whether or not they have anything to hide. Because if I'm pushed balls to the wall, you all know that I'm the kind of person who's like, okay, let's go. I don't have anything to hide, so I hide nothing. If it comes down to this and we've got to do this, go ahead. Look at all the skeletons in my closet. You'll see that, they all died of natural causes except for a couple. Oh. Oh, goodness sakes. So back to the script here. Real estate information is a matter of public record. These interrogatories and document requests may also be relevant to determine the interrelationship between plaintiffs and the Shekinah Church International, a matter placed in controversy by plaintiffs' complaint alleging that defendants made false statements regarding that connection. Documents related to other organizations, such as Mission 2020, may show connections between plaintiffs and Shekinah Church International that would escape detection through more direct inquiry. Defendants have sought information necessary to test plaintiffs' claim that defendants' social media has resulted in a loss of influence and revenue. Oh my God, this reminds me of being in the grocery store when you try to get that bag to put your apples in, and the bag won't ever open, and you sit there for like 62 minutes trying to open the frickin' bag. That's the moment I'm having right there. Sorry for you guys having to live through that with me. Thank you for sticking in there with me. Let me see here. There we go. That's 6. Now here we are on page 7. And in interrogatory 16 states that Robert Shin would need to identify all companies or organizations that have paid or sponsored 7M or its employees and or affiliates to act as influencers and or promote or advertise their products, including monetary, in-kind, or other. Interrogatory 17 states that identify all companies, organizations, or other clients who have hired 7M or any of its employees and or affiliates for monetary, in-kind, or other payment. Document request 6. This is weird. Okay, it goes from interrogatory to document. That's why, okay. Document request number 6 has documents sufficient to show any compensation paid to you, including monetary, in-kind, or other, attributable to your social media activity. Okay. Document request number 7. Documents sufficient to show any compensation paid to you, including monetary, in-kind, or other, attributable to booked performances or appearances by 7M dancers. Document request 8. Documents sufficient to show any compensation from any and all sources, including monetary, in-kind, or other paid to plaintiffs. And document request number 9 is a full financial accounting and tax returns of 7M. Ooh, whoa. Document request 11 says that They want the complete ledger showing the receipt of all donations, tithes, gifts, and income for the plaintiffs, including the source of those amounts, the dates they were received, and whether anything was provided in exchange for them. Document request number 16 is documents sufficient to show the income and expenses of James Derrick, including but not limited to his tax returns for the stated period and any statements showing child support paid during that period. Ooh, now we're going to bring his baby mama and child into this? What? What business is that? Huh. I want to know how much child support. Sorry, slurping down my tea. Lavender lemonade is very, very good. Okay. And then document request 20 is asking for documents sufficient to show each company paying or having paid 7M or its employees or affiliates as an influencer or advertising partner, including monetary, in-kind, or other. Document request 28. All documents or statements supporting your claim that you have incurred $50,000 or more in damages because of defendants' alleged actions and any documents showing your attempts to mitigate those damages. Well, that was provided, wasn't it? We saw that in part 10, where they had no problem coming forth and showing just from the LA Clippers that in the future thing that, that was looking into the billions. So I'm sure that's something they were planning on doing. And then information regarding James Derrick's child support payments is relevant to, number 1, plaintiffs claim that defendants made false statements that he did not pay some or all of the child support he was obligated to pay, and number 2, that James Derrick's claims related to damages. The remainder of these requests is related to the remaining damages claims. We'll put that in there. Defendants also sought information relevant to plaintiffs' claim of emotional distress. In interrogatory 21, identify the emotional consequences you suffered as a result of the behaviors alleged in your complaint. I do believe they did that. Let's see. Interrogatory 22 says, identify any and all damages you attribute to the emotional distress you allege in your complaint. Interrogatory 23 says, list any and all therapists, counselors, psychologists, psychiatrists, or mental health professionals you have seen or received treatment by since January 2012, including their contact information, length of treatment relationship, any diagnoses they issued, and the treatment regimens prescribed or otherwise directed at, including but not limited to counseling, psychological treatments, and medication during your treatment thereby. List any other mental health diagnoses and their respective treatment regimens not provided in response to interrogatory number 23. Interrogatory 29. Provide copies of medical records, charts, notes, records, and prescriptions for all therapists, counselors, psychologists, psychiatrists, or mental health professionals you have seen or received treatment by since January 2012. Okay. Now, let me opine here. How, if this was out there and given to KJ, do you know how she could use that information to embarrass him to ever work in his field again? These are very sensitive topics. And I really see how necessary it would be for 7M to protect this information. Okay, well, I guess that I'm being answered right here because it says, while this information is sensitive, plaintiffs have placed these matters in controversy by bringing a lawsuit alleging emotional distress. Some document requests explore the claims that defendants made false statements that dancers were not paid for their work. Document request 14 wants documents sufficient to show compensation or wages paid, including monetary, in-kind, or other, to its dancers and employees by 7M, reflecting any withholdings taken from the compensation. Document request 18, lease agreements for the 7M dancers during the stated time period. Document request 19, all documents and communication regarding content creation or dance routine planning by 7M, including but not limited to the process for selection of music, sets, clothes, and choreography. Why would that be relevant? I would think that that would be like part of the trade secrets. I mean, you don't want that to be out there so everybody else can know your modus operandi. That's, wow. Document request 24. All documents showing work schedules and or hours worked by 7M employees and contractors, including but not limited to meetings, appearances, performances, content creation, and or dance practice or lessons. Will plaintiffs may express outrage that defendants accuse them of participating in human trafficking. By bringing suit, defendants are entitled to discovery relevant to the defense of truth. I am feeling bad for 7M because it seems to me that the burden of proof needs to go to KJ showing why she's saying those things, not for Robert Shin and 7M to go and put their bellies up and show every single thing that they've ever worked for and every thought they've ever had and any doctor they've ever seen so that we can determine if Katie Joy has a right to be reckless. I would be so upset. I mean, I understand it's all part of a trial, but this would be very, very distressing if I was 7M, Robert Shin. I really feel for the plaintiffs. I really feel for the victims in this case. I really do. Finally, plaintiffs claims that defendant made defamatory statements regarding the marital status of Miranda and James Derrick. Accordingly, defendants sought information that would tend to prove that defendants' statement were false or establish a defense of truth. Document request 27. Documentation evidencing the legal marriage of Miranda and James Derrick. This information is unlikely to be sensitive and is directly relevant to claims made in the amended complaint. Number 2, plaintiffs have failed to show good cause exists for the issuance of a protective order. I disagree. Just a second. I gotta huff on my albuterol. Let's see here. Minnesota Rules of Civil Practice provides that upon motion by a party or by the person from whom discovery is sought, and for a good cause shown, the court in which the action is pending or alternatively on matters relating to a deposition, the court in the district where the deposition is to be taken may make any order which justice requires to protect a party or person from annoyance, embarrassment, oppression, or undue burden or expense, including one or more of the following. Okay, so they're attempting to say here that the plaintiffs have failed to show good cause exists for the issuance of a protective order. And that's where we're going through this, and we're reviewing what the Minnesota Rules of Civil Procedure say. Okay, so that's where this is taken straight out of the Rules of Civil Procedure. It's not so much a document or anything specific to the case. This is the rules of procedure as stated. So they are as followed: that the discovery not be had, that the discovery may be had only on specified terms and conditions, including a designation of the time or location or the allocation of expenses for the disclosure or discovery. 3, that the discovery may be had only by a method of discovery other than selected by the party seeking discovery. 4, that certain matters not be inquired into, or that the scope of the discovery be limited in certain matters. That discovery be conducted with no one present except persons designated by the court, and that a deposition, after being sealed, be opened only by order of the court, and that a trade secret or other confidential research, development, or commercial information not be disclosed or be disclosed only in a designated way, or that the parties simultaneously file specified documents or information enclosed in sealed envelopes to be opened as directed by the court. Okay. I don't really see how that provides the argument here for the issues that are of concern, but Katie Joy is a very unique entity. No professional journalist would be going out as far as she has, or they wouldn't have a job. Plaintiffs seek an astonishingly broad protective order that would sequester the interrogatory answers and responses to documents request in counsel for plaintiff's office and prevent Ms. Paulson from accessing these documents, allowing only her attorneys to view them, but not make any copies. This, plaintiffs contend, is because defendants have posted personal contact information about plaintiffs and disseminated depositions from other cases on their social media accounts. Okay, there you go. There we go. This is what I wanted them to say, but had to wait for it. Did you guys all wait for it? We waited for it, and there it is. Basically, as you can kind of tell, all these memos and papers are just a big shit sandwich. You got all this superfluous information on both sides. Shit on each side, and then this little tiny piece of meat in the middle. Or a turd, as it may be in this case. That is just what this is all about. I mean, so much is wasted in courts and all of them, pontificating and banging their chests and everything when it's just like, you know what? Let's just get to the reason why we don't want to do this. Oh, because she does this. She has a history of doing this. All right, there you go. Okay, boom. But no, we must make an entire shit sandwich. Kind of a shit sub sandwich at this point. Anywho. Plaintiff's memorandum supporting its motion for protective order does not identify the material that they characterize as their personal contact information. The material that plaintiffs claim defendants posted about another case consists of a few pages of trial testimony, a page of deposition testimony, and what purports to be a witness statement of some kind. She's referring to Slavic Declaration Exhibit P. She goes on to say, there is absolutely no evidence that these materials were subject to a protective order. In fact, defendants' posts indicate they are public documents available on Pacer. Oh my God, she did not just go there. No, she did not just go there. She didn't, because, oh my God. Basically, when you get a Pacer account, you sign a whole ass contract saying that you're not going to disseminate the information that you get there. Oh, she did not just use that. Oh my God. She did. No. She did. Oh, I'm gonna have to get the Pacer document out and no. No, she did not. She did? Okay. All right. Oh, she didn't. She didn't. Oh, if I didn't fear that there's a whole entire avalanche up there, because I don't think I've sent in my whole Pacer application. I think I was looking at it and read all of that stuff. So I would grab it right now, but I'm afraid that this avalanche of paperwork would fall upon us all and kind of be a Mount St. Helens situation that I'm not willing to deal with at this moment. But I'm going to get out the Pacer document and show that is not a defense. Just like you can't go and do a credit report on somebody and go on social media and post things that could impact a person's ability to gain employment, etc., because a lot of times people have arrests on their record, but no conviction. A lot of people have arrests, but no conviction. A lot of times situations are out of control and people are arrested because you don't want to fight with the cops. You get arrested and then things are sorted out and okay, it never should have happened, never should have been arrested. There's no conviction and whatnot. But people who are reckless, would see something and be like, oh, that person's been arrested for this and blah, blah, blah. Yeah, well, where's the conviction? The damage would be done because then they see that person as arrested for this. And I mean, there's a lot of things. That's why, anything like for credit reports or anything like that say that this information is not for public use. This information is not to be used to consider for employment, etc. I mean, you have to be careful with information. You can't defend that public documents available on Pacer. You have to provide your own information to get a Pacer account. That's okay. I'm just over here shaking my damn head going, no. It's just Katie Joy shares things that she knows she should not. That if anybody shared those kind of documents about her, she'd have a real problem with it. She'd have a real problem with it. I am not a diagnostician. I have not and cannot make a diagnosis on anybody. But I have seen an instance where Katie Joy revealed somebody's address on somebody else's account a while back. You guys know what I'm talking about. It was on Uniball, I think, when she was friends with Uni. And she provided a document that showed an address of somebody. And right away the mod saw it and said, take that back or whatever, something to that effect, like, that person's address is here. And Katie Joy was like, oh my God, I'm so sorry. Oh my God, I'm so sorry. I didn't mean to do that. Oh my God, I can't believe I did that. OMG. Oh my God, I feel terrible. So terrible. And, the next day, as the story goes, Uni was like, oh, okay, yeah, it was a mistake. It happens. She's like, I feel terrible. I would never intentionally do that. except for that you do that and you continue to do that. That pattern of behavior pretty much is the Wikipedia definition of sociopathic behavior, in which somebody understands that the behavior choice that they are making is wrong and that they wouldn't want other people to do it. They know it's wrong and they choose to do it anyway. And they do it repeatedly. And then, oh, I didn't know. But if they're praised for doing it, then they're like, yeah, because I'm a freaking badass and I fornicate all the time. Then if they're criticized for it, it's like, oh, I'm so embarrassed. I did not need to make this mistake. That's what she does. She plays dumb. She knows exactly what she's doing. But she's not sly. It's really weird. And this flippant statement that her attorney just signed her name to in defending this right here is problematic, in my opinion. To back this up and say, in fact, defendants' posts indicate that they are public documents available on Pacer. If this said Google, I'd be okay with it. But Pacer is not necessarily open to the public. Like I say, you have to provide your information. They go through, they check it, and then they give you access. So they can basically see who's looking at what information if that information goes and gets disseminated, I would assume. So to use that and defend it, and the attorney would know what Pacer is. When you study law, LexisNexis and Pacer and all of those vessels of information are readily available. So just as real journalists, when I think she worked for a while for some publication, maybe that's where she learned how to source information from Pacer and whatnot. But they're not necessarily just something that your average layperson has access to or can just find on a Google search. That's why this is problematic. Anyway, defendants did post that discovery is about to get real. Oh my God, she did not. She didn't. She didn't. Are you kidding me? She did? Okay, this is why a restraining order, this is why the protective order is needed. She freaking said this? What in the freaking... Oh my word. No, she didn't. Oh. So yeah, she did post that discovery is about to get real. Oh my God. And you defend that? Oh. And then it says, defendants did not post that they intend to post sensitive information they gleaned through discovery on their social media accounts. Okay. So we're going to go ahead and say this. Defendants did post that discovery is about to get real. Defendants did not post that they intend to post sensitive information they gleaned through discovery on their social media accounts. Yeah, but she said that she's going to ruin them and she's not going to be happy till they have nothing. But we'd have to take that sentence apart and see what exactly did you mean when you said that. Oh my God. Nor is it reasonable to infer such an intent from a fair reading of the post. Parties to defamation suits are entitled to obtain discovery that is relevant to the claims asserted in the pleadings. Defendants are entitled to obtain discovery as to plaintiffs' claims that the statements made by defendant were false. Assuming, arguendo, that despite the complete lack of showing of good cause, the court finds that a protective order is appropriate, such an order should be narrowly tailored, consistent with defendants' right under the First Amendment and the need for due process. Defendants must be allowed to participate fully in the discovery process and provide meaningful assistance to their attorneys. I don't think anybody's arguing that. I think that they're arguing that they need to make damn sure she doesn't go and run off with that. And even if she loses, if she has access to all of that, she'll make a fortune blabbing about what she found out. So if she has to pay out any money, she'll just make it back by doing that. This isn't about the First Amendment. The First Amendment left this discussion long ago. I mean, if they could trust that she's going to be using it for that intended purpose and not talk about the case or anything in it until after all litigation is settled, then we wouldn't even have the need for a protective order to be suggested. But the conclusion states that, for the reasons stated above, defendant's motion to compel discovery must be granted and plaintiff's motion for a protective order should be denied. Respectfully submitted by Troutman Martin Law, PLC, by Jennifer Moore. Dated October 31st, 2022. And with that, my friends, we are... Oh, and you know what? We've got these angel numbers on our side because that was 11 pages. And let me see here. 11 pages for part 11. 1111. We've got it on the ones, baby. Oh, how does that song go? I'll be wishing on the 11s. Something like that. But 1111 is a huge angel number. So part 11 has 11 pages. We've got angel numbers all around us. That's good. That's good. Maybe my feeling of impending doom will be lifted. Thank you for listening. Please share your thoughts in the comments. I really like to see how your take is on this. If you're new to Katie Joy and not sure why there is controversy surrounding her, certainly there are Facebook groups, there are Reddit pages, there are so many YouTube creators who do a good job of exposing why Katie Joy is problematic. I think that the reason why I really became upset with her behavior is the terrible way in which she allows her child to be treated and talked to by Toad and her. It is no way to treat a child to scream like that and scream at bedtime and scream and allow a child's father to scream that they've been screaming at that child for hours now, and that she just keeps herself locked up in a room to sit there and do this so she doesn't have to be an active mom, wife, housemaker, and allow the other parent to be extremely frustrated, and then to sit there and claim that you have such a medically fragile child that, you demand all this special treatment for you, but then you allow verbal abuse to that medically fragile child. No child should ever be subjected to yelling like that under any circumstance ever. Especially not one who's going to face medical challenges all of their life. I think that that's probably one of the leading reasons why people are a little repulsed by her behavior, and others. It's just this. It's that you just see that, you know what, yeah, all of us could do the things that she does and make a living off of it, but we don't, because it's not decent. It's not right. It's reckless. It's rude. It's unfair. It's reprehensible. And I'm not sure if Jennifer Moore knows what year it is. She may think it's 2026 by what I saw that hearing. But I did put another little clip up of the courthouse for any other creator who is out there who is also covering the trial. Please feel free to use my footage or pictures of the courthouse as you like. I had a first part to it, but an employee of the courthouse had walked kind of out right where I was filming, and it was like, I was able to kind of whisk away, but I didn't feel right about it. So it doesn't make sense, kind of that. But the point is that there's more pictures of the courthouse for anybody who'd like it. Thanks again for listening. Please like and subscribe. It's the best way to support me and know that you're out there. I really appreciate each and every one of you. You know that I do. And with that, I will close episode 11. Thank you. Have a happy Monday, if that's possible. Bye-bye.